So good afternoon. My name is Nicole Hilton. I'm an Economic Development Officer with the County of Simcoe, and I will be your moderator today for this afternoon's session. I'm just having a few people roll in here. And thank you all for being here today. The Ask an Expert series is led by the County of Simcoe Economic Development Office. And over the last 4 years, we have been able to bring organizations throughout the county some excellent content as you navigate the current business environment. I encourage you to keep an eye out for future webinars as we have a lot of great content presented through the series throughout the year. I also want to thank our regional partners who have assisted with these webinars, which include the Small Business Center of Barrie, Orillia, and Simcoe County, South Georgian Bay Small Business Enterprise Center, Orillia Area CDC, Nottawasaga Futures, North Simcoe Community Futures Development Corporation, Community Futures South Georgian Bay, Sandbox Center, Georgian College, and Lakehead University. Through the registration for today, several of you shared questions with us. These were provided to our guest expert, and some will be answered through the presentation today. But the more specific questions will be addressed once the presentations conclude. If you have any follow-up questions at any time, please type it into the chat function. You should be able to find the chat button, I believe, at the bottom or the top of your screen. And we will address as many questions as we can after the presentation concludes and within the hour that we have allotted for or allocated for today's session. It is my pleasure to have the opportunity to facilitate today's session and welcome the Director of Intellectual Property for Intellectual Property Ontario, Jarrod Hicks. Jarrod has an experience in numerous divergent technologies, including cloud computing, artificial intelligence, machine learning, and neural computing. Prior to joining IPON, which is Intellectual Property Ontario, he thrived in intellectual property procurement and prosecution, representing several multinational companies in the Silicon Valley. Silicon Valley. He holds a bachelor's degrees in chemical engineering and mathematics and obtained his JD from Santa Clara University. He has been a registered U.S. patent lawyer for 15 years and really enjoys working with startups and scale-ups, as each company has its own strengths and challenges, and appreciates the opportunity to help them succeed along their individual journeys. At this point, I will turn it over to you, Jarrod.
All right. Thank you so much, Nicole, and thanks for letting me speak on behalf of IPON at this event. We like to be able to reach out to as many different startups and companies and innovators that we can, and so this is a great setting to be able to reach more of an audience. So we do appreciate that. As Nicole mentioned, I'm a registered U.S. patent attorney. I've been practicing for over 15 years. That background just really touched on the AI and computer science specific areas of my background. But having worked for so long, I've really touched on just about every technology you could imagine, and have been successful in prosecuting patents over the length of that time. So I will get into the slides here. I have a lot of material that I'd love to be able to get through. We'll see how time dictates, but let's get started. The agenda, 3 main points of the presentation: why is IP important, why you should care about it, why your company should invest in it, what we're able to support and help with companies with their IP, and then the kind of thrust here is the effective IP budgeting strategies that you may be able to employ at your companies to better utilize IP. So why is it important? It's important so that you don't lose out on opportunities that you otherwise may be able to take advantage of. As that quote says there, we come up with lots of great ideas up in Canada, but then we don't seem to follow through on it and make use of those ideas in a way that is commercially viable and successful for the companies or the innovators who have come up with the ideas. Businesses that manage their IP effectively are 3.5 times more likely to export and make money through exports to other countries, almost 2 times more likely to be high growth companies, and about 12% more likely to seek financing to grow their operations. That's overall for businesses in Canada. only 9% of innovative companies have an IP strategy. An IP strategy is going to dictate what, when, where, and why you're going to be pursuing IP and paying money into your IP to better the position for your company. Only 14% of companies with research and development functions hold or use patents, which is shockingly low. And only 17% of companies believe that IP protection is needed for them to be successful, which is also an unfortunate number when you look at the grand scheme of things and how other jurisdictions operate and how companies there are successful. So SME, that's a smaller, medium-sized enterprise, typically indicated by a company having 500 full-time equivalents or less employees. So SMEs holding registered IP rights are 3 times more likely to expand domestically within Canada and almost 4.5 times more likely to expand internationally, which obviously would benefit their market because our neighbor to the south has a lot more money and people for you to access than you do here domestically in Canada. So if you can tap into the US market or other foreign markets, you're more likely to be able to take greater market share from your competitors. Venture capital, another reason why IP is important. You can see the differences between companies who do have patents and companies who do not have patents. The average VC deal is almost twice as large if you do have patents. Funding provided to startups is skewed towards companies that have patents. Funding provided to late stage companies, which is where the VCs really want to get in so that they can make money on these companies because they see a future there. You can see that's incredibly skewed towards companies that hold patents. And then exiting versus IPOs, you're almost 6 times as likely to do so if you have patents in your company. So what can IPON do to help out companies? Remember, IP isn't just patents, but it's in innovation tech. That's often where we look for IP protection is through patents. So IPON, it's a provincial agency. It's launched in 2022, really started rolling in 23. It's focused on providing IP services that support Ontario businesses, small and medium-sized enterprises, and researchers to innovate and grow through IP. The services that we provide, there's education, both a foundational IP education course and IP benchmarking, along with an IP workshop, which is a 2-hour virtual get together with some other innovators and small business leaders, along with one person or more from my team to discuss IP strategy and IP in general and how it can affect the case study that we're looking at. Benchmarking allows you to identify weaknesses or areas where you may be able to improve your business with regards to IP. It's an online tool that you can access anytime you'd want to make use of it to, again, benchmark your progress to see if you're improving in those areas that you needed help in and to make sure that you aren't backsliding in any other areas. We also provide IP funding. It's direct funding to the companies for the cost of IP protection and commercialization services that are acquired through a service provider located in Ontario. And then it's conditional on an approved scope of work. We have a regimented procedure for how you would get a scope of work put into place with a service provider, reviewed by my team. Once it's approved, you can begin work. And then we have a partial reimbursement model where 80% of the costs of the IP work would be reimbursed to you once the work has been completed and you provide an invoice to IPON. So it's an 80-20 split. You still have to pay for any taxes that are on top of that amount. Because we're a provincial agency, we can't reimburse for taxes. But other than that, it's a fairly good deal. We also have an IP intelligence group. We've already created several patent landscapes that examine the sectors that we serve, medtech and life sciences, AI, mining, as well as data-driven technologies, and then the auto industry, both electric vehicles and autonomous vehicles. We have many client events that we participate in, both outreach and networking, so that you can correspond with other clients of IPON as well as other ecosystem partners that would be able to help you along your IP journey. And then we do have some advanced IP education modules that build on the skills that you learn in the foundational IP education course and touch on discrete topics more specifically tailored towards understanding them, such as commercialization and IP audits. So in order to access IPON services, you must become a client. In order to become a client, you need to be a small or medium-sized enterprise, less than 500 employees, and be located in Ontario. You have to operate in one of the served sectors, again, medtech, life sciences, AI and data-driven technologies, vehicle tech, or mining and advanced manufacturing as it relates to any of the other sectors. You must own or be an exclusive licensee of the IP that you're intending to commercialize or monetize in Canada. And abroad is also fine, but as long as you're also going to be benefiting Canada with your IP. And then you need to operate in Ontario and intend to grow the business in Ontario. So if you're interested in applying because you have a company that's incorporated, or you're an innovator working with a university or a researcher, that's the link right there. It's fairly easy. If you also just go to our homepage, there's an apply button at the top of the homepage that you can link to. And then you can see not only all of the eligibility criteria that are listed there that look very similar to this, but it'll also give you the application that you can fill out and start your journey to becoming an IPON client. Our onboarding process is straightforward, but again, it takes time. My team has to review everyone's application to ensure that all of the eligibility criteria has been met. So you would complete the intake form. Once that process of ensuring that all of the eligibility criteria is met, then we'll send out a client agreement for you to sign, which stipulates all of the terms and conditions of being an IPON client. Once you are a client, once you sign that client agreement, you can remain a client as long as you want, or up until you are no longer eligible because you have more than 500 employees, you sell your business to a company located in the US, or for some other reason that you would no longer be eligible. So the onboarding process, you get an email out with a bunch of information and links in it that gives you access to the benchmarking tool, to the a needs assessment form so that you can let us know what kind of IP help you need so that we can best tailor our services to meet what you want. There's some other information there as well. It introduces you to your client management person. And then it also allows you to access one of the IP team members, either myself or one of my team, so that you can have a discussion about what you really need to know so you can begin your journey. After you're onboarded, you start receiving your foundational IP services. You can do the education course. You can do the benchmarking. You can sign up for the workshop once the education course is complete. And once those prerequisites are completed, then you can start accessing the funding. We have funding calls that are announced fairly routinely. The last couple have been uncapped, meaning that there's no limit on how much money you can access, up to the amount that you would be able to cover for your 20% plus taxes. So if you have a large IP spending or a large IP spend upcoming, I would behoove you to become a client so that you'd be able to access that funding to help support that. And once you start receiving the IP services and support, you continue to receive them as long as you're a client. You can see there a list of some of the partners that we work with in the IP ecosystem, and there's many, many more than that. If you are affiliated with any of these partners, I implore you to ask them about our program and how you can get involved with us. So, how do you effectively budget for your IP spend? It's a very, very important question that often comes up. We look at 6 principles of IP budgeting to try and simplify things. You can see the bullet points there. You have the IP and business strategy alignment is crucial. An IP strategy does not help your business if it is not supporting and aligned with your business strategy. If your IP strategy is to patent one particular invention, but you have no goal of ever commercializing that invention, then your IP strategy and your business strategy aren't aligned, and you're not going to be successful in your endeavors. If you're spending money to protect IP that you're never going to be able to utilize commercially, then you need to rethink what you're doing and why you're doing it. So in order to get an IP budget in place, you need to ensure that your IP strategy aligns with your business strategy. Second point, you should ask your counsel, your lawyer or your agent, whoever you're working with, for a 24 to 30 month IP spend cash flow. That's as a minimum, that amount of time. What you're looking for is to find out under your current strategy and what you have filed and where you have filed it, how much money it's going to cost you to maintain your IP that's already filed. That's your IP spend cash flow. You'll see dates when things are going to come due. You're going to see prices attached to how much things cost. And then you can properly budget for how much you need to spend on your IP to not only maintain what you already have filed, but also with an eye towards any new filings or new endeavors or new product lines or anything else you're going to be trying to do. You need to make sure that you capture all aspects of your IP spend and not just a hope as to how much it's going to cost, but rather know how much it's going to cost. You need a budget for internal time and project integration, the third point there. Nothing happens immediately. Even best laid plans often get dragged out and need more massaging before the end product is actually created properly. So you need to make sure that you have the proper resources allocated to your IP and that you're giving enough time for that IP to properly be protected before you try and go to market with it. The fourth point here, understand your options. So don't just have plan A. And if plan A fails, then you fail. Make sure that you have plan B and C for your IP prosecution. Should a particular patent go through the office and not be approved, what are your other options for protecting yourself in the market that you're trying to access? What other ways can you protect your product? Did you file patents simultaneously on different aspects of the product so that if one fails, the other one can still be successful and protect you when you're accessing the market? All of these things need to be thought through, not only in your IP strategy, but in your filing strategy, as well as accounted for in your IP budgeting. The fifth point there, as you scale your spending, track your overall cost to protect IP. It's important that you don't allow your IP budget to eat up more than is a reasonable amount of your overall spend. And if that does appear to start happening, then you need to refocus your IP protection to only covering core aspects of what you are actually commercializing, and you may have to let other things go. It's a tough realization if you've already filed a patent application to abandon it because you can't afford to prosecute it. But if the ulterior or the alternate is that your business goes under because you can no longer pay your bills, right? It may be better to cut your losses when you can, salvage the business, and then again, protect your core innovations and move forward with those protections. The sixth point here is something that you just learn over time. Make sure you have strong counsel relationships. It's great to get great value on your IP spend and working with someone who is less expensive than maybe another alternative out there. But if you don't have trust and a strong relationship with your IP counsel or your IP agent, you're going to be missing out on things, right? They need to be a trusted resource for you, not just a cost center. You need to know that you can get advice from them when you need to, and that it's not going to cost you money to do so, but also that when you are getting advice from them, it's worth money if you are paying for it. It's your billable advice versus your non-billable advice. The more you can get non-billable advice from your IP counsel, the better off you'll be, as long as they are experienced in what they're counseling you about. And then remember that transactional support is different from strategic support. So building up a strong IP strategy so that you know the direction and focus of your company and your IP spend is very important at the outset. But then you also need support for any transactions that may occur along the way, and they may be different counsel that are doing that for you. It doesn't always have to be through the same person or the same firm. And so it's important to weigh and figure out where your money is best spent as you move forward in your growth. So how do you do all of this now as a startup and through scale up? So no one has unlimited resources, so you can't just protect everything that you would like to. And so you focus on your core technology. As you scale and develop new innovations, you incrementally capture those improvements in accordance with your IP budget. You've already set out your IP budget. You said for this year, we can file 2 applications to capture new incremental improvements on our core innovations. And so as those come forward, as they're discovered through your research and development, you need to figure out what those 2 things you can capture are. And that's all you capture that year, because that's what your IP budget dictates. The way that you make sure that you're focused and do this effectively is your IP strategy. Again, that's the first piece that you put into place so that you understand what you should be doing, why, where, when, all those great questions. So for patents, we have some filing strategies that will help with cost savings. The PCT, the Patent Cooperation Treaty, gives you an ability to access foreign markets, sometimes more cost effectively than directly filing in those foreign jurisdictions. Unitary patent process within the EP, the European Union, versus national validations within individual countries that you would want to enter. That's another way that you can bring down your costs on patent filings. And then the global patent prosecution highway. If you're able to get an allowance in one jurisdiction, you can sometimes leverage that in other jurisdictions to alleviate some of the prosecution costs that you have through those patent offices. So this is looking at PCTs. With your non-PCT filing, if we assume you file a U.S. provisional patent application, you can see the approximate costs that you can expect for drafting and filing of that. You then have 12 months to file a full application. In a non-PCT scenario, you're going to file that in every country that you want to get protection in. So here, the examples are the US, Canada, Japan, and the EPO. You can see the associated costs with each of those. So when you do this approach, either you file a US provisional and then 12 months later have to file the full application everywhere you want to enter, or if you don't file a provisional, you just have to file the full application everywhere you want to enter. Using a PCT, the Patent Cooperation Treaty, it gives you some more leeway. Here, if you file the US provisional again, your 12-month window, you can then see that you have an additional 18 months before you have to figure out where you would want to enter. That gives you time to test the market, to make any improvements you may have had before when you originally applied, and kind of figure out what the fit is and whether you actually need to enter Japan or whether you don't think you're actually going to be able to compete against the other competitors that are in that country already. So that extra 18 months can really save you a lot of money if you're assuming you had to enter multiple jurisdictions, and maybe you don't have to, and you only have to enter the US and Canada or something much simpler. So using the PCT not only allows you to file a single application, which is then examined in the receiving office, and then those results of that examination are given to what other jurisdictions you decide to enter in ultimately. But it also gives you that extra time to figure out what you really want to do with your invention. In the European Patent Office, national validation is required. If you file an application in the EP, it is actually a regional office. It's not any individual jurisdiction, and there's no such thing as a European patent. Rather, you have to get it validated in each country you want protection in. So in the UK, in Germany, in France, in Italy, in any of the individual countries that you want protection in, you have to have your approved and allowed, European patent application validated in each of those countries, which costs money, sometimes have different translation requirements. The renewals in all the different countries need to be made separately. And then it each has a life of its own, meaning that if someone challenges you in Italy and your patent is invalidated in Italy, your German patent and your UK patent are not automatically invalidated, which is great if that should befall you. Unitary patent makes things simpler. The EPO, in effect, handles the validations. You just say where you pay the money to get the unitary patent issued, which is in certain jurisdictions. If the countries that are listed under the unitary patent make sense for you and you want protection in all those countries, then it can certainly be a more cost-effective way of doing it because you only have the 4 renewals and the rest are free. Versus if you did national validation in 6 countries, you're going to have 6 renewals. For the unitary patent, you'd only have 4. So that saves money on maintaining the patent after it issues. You do have to translate the whole patent into a second language, which you would not have to do for the national validation. And all of the validated patents rise and fall together, meaning if one of them is invalidated, they all are invalidated. So you need to make sure that you have a strong patent filing if you're going to seek a unitary patent. And then you have multiple jurisdictions that you would need to have that protection in order for it to be cost effective to go that route. But Again, it saves on the renewal fees over the life of the patent, which reduces that. It also would save on the prosecution through foreign agents in each of the different jurisdictions that you would have to do with a national validation. Here are some charts that also show the difference between the national validation and the unitary patent. So after you get a grant from the European Patent Office for your European patent filing, now you have, for national validation, claim translations. They have to go into French, English, and German. For most of us, they were probably presented in English, so you just have to translate them into French and German. And then you have to determine which countries you want to validate in. Some of the examples are given there. For the unitary patent, you get your grant. You have to validate it in all 17 signatory countries. And so then it applies to all of those. Whichever ones you choose are the ones that you're going to get validation in. And then again, the EPO kind of handles the overall cost. It just sets out the amount of money that you need to pay. And then it applies in all the jurisdictions you select. Global patent prosecution highway. Again, as I briefly mentioned, this allows you to leverage an allowance in one jurisdiction if you're pursuing the same patent claims in other jurisdictions. So the example here, Patent Office A reviews and prosecutes your patent application. Your claims are reviewed, amended, and then allowed and issued. Once you have that allowance in Patent Office A, you can turn to Patent Office B and say, hey, Patent Office A allowed my application based on these claims. I'm presenting these claims in this jurisdiction as well, so you should allow it for the same reasons that they found it to be allowable. And that typically expedites the prosecution. It can cut off multiple rounds of office actions and review by foreign associates and simplify and make things easier for you. So you see the advantages there. The disadvantages, not every patent office follows what was done before. There are a few patent offices out there that kind of dictate what they want, the US being one of them, European Union being the other. If you get an allowance in one of those jurisdictions, you can be fairly confident that you'll be able to get allowances in other jurisdictions based off of that allowance. So CIPO, the Canadian Intellectual Property Office, will generally follow what the USPTO does. And then other jurisdictions will generally follow what the EP does. So if you have allowance in the EP, you can be pretty confident that you'll get allowance in some of the other jurisdictions as well. Here are some cost-saving tips when you're filing for patents. Make sure that you have a good application draft. Poorly drafted, quickly drafted applications that are drafted either in-house or by those who are not as experienced in the field as they should be, can really defeat your chances of getting that application allowed. And sometimes more problematically, even if it is allowed, it can really render the resulting patent insufficient for your needs. If your claims are overly broad or overly narrow, you may not be able to assert them, and they may not protect your product as you've intended them to when you initially filed the application. So it's important that you have someone who knows what they're doing helping you draft that application. Always keep the global perspective in mind, even if you're not intending on entering a foreign jurisdiction when you're filing. Make sure that your IP filing strategy, part of your IP strategy, understands what else is out there and has a global perspective as to what you may do in the future, should you have the benefit of more resources. And that also should be included in your application drafting. Certain jurisdictions require certain aspects to be done different from others. And so you need to ensure that your application accounts for all of those variations if you ever intend on possibly entering a different jurisdiction. So you need to know why you're doing this. Again, that's your IP strategy. It helps when you're figuring out how much money and resources you want to invest into your IP asset. Review and prioritize your IP portfolio. Again, you look at what you already have. You look at what's under prosecution, and you make sure that they still make sense with your IP strategy and your business strategy. Be honest and trustworthy with your counsel. If your business plans change or your IP budget gets restricted, make sure they know. so that they can help you navigate the waters and the uncertainty that may be coming down the pipeline with whatever's already in prosecution or what you're planning on doing in the near future. Make sure you use really good counsel everywhere, not just at home, but any foreign agents that you're relying on. Make sure they know what they're doing and are giving you reliable advice back as you're trying to prosecute your patent portfolio. And then it's always a good idea to be on your counsel's good side. So it's a relationship you want to build up over time through trust and mutual respect. So make sure you give your counsel respect and make sure that they respect you. For trademarks, there's two different ways to think of trademarks. You can either have common law trademark, means you just use it, versus registering a trademark right. That would be filing with the Canadian Intellectual Property Office or with the USPTO or some other governmental office. So trademarks, if you just start using a mark or a name in commerce, then you can acquire a common law trademark right. It's geographically restricted to where you're actually using it commercially. And then if you ever need to litigate that against someone else who's infringing on your mark, it can be very difficult to establish that you have a common law trademark. In litigation, it's much easier if you registered that, because now you have a presumption of validity to that mark. And then your challenger, the person that you're litigating against, has to prove that your mark should be invalid. Registering a trademark also gives you more enforcement options, more damage recoveries, can be cited against later filed applications during prosecution of those applications, so you can defeat someone else's attempt to step on your toes with your mark. And it's easier to enforce, especially online, which is where a lot of these marks end up being litigated and conflicts arise. So, however, registering your trademark rights costs more money. Common law, you just use it, and then you can acquire the right to your mark just through use of it in commerce. So if you don't have the money up front, you can start using the mark and hope that you can acquire common law rights to it. And then if you do get the money down the road, you can always file your application later. So it's important that you run searches, not only for trademarks, but also in the patent world. It allows you to identify any obstacles to registration if there's other using marks similar to yours, whether it's in the same area of the market that you're doing or somewhere else, so that there's no confusion or ambiguity. You can flag marks that may be identical or similar to yours, and then possibly not register in a jurisdiction where those marks exist, but do capture your mark in other jurisdictions. You can figure out how likely it is that you're going to be able to get registration without having to file your application or registration first and then spending the money to do that and then losing out in the end. It also will help you figure out what other players are out there, because you don't want to have to rebrand down the road, because it's quite expensive. It takes a lot of time, and you can end up losing goodwill and market share and customers during your rebrand just because you're no longer the same entity in their eyes. So these searches also help you with budgeting, because you can understand how much money needs to be allocated to overcome the obstacles in the registration of these marks and in which jurisdictions you would need to file in. Some cost-saving tips. This is just kind of a breakdown of what trademarks are, right? It's a source indicator. Very common are words like a company name or slogan, and designs like the logo of a company. Less common, and some of these aren't even available in Canada, but only in the United States. But it would be color, a 3D shape, moving images, mode of packaging goods, sound, scent, taste, textures, all kinds of things, patterns can be trademarked. Each class that your trademark is filed under costs more money. And it's a multiplier. So if you file in 6 classes, it's 6 times as expensive if you file in 1 class. The US and Canada both give you a few classes for free with your application, and every class beyond that costs additional money. And the classes dictate where you can use the mark. So it can be like t-shirts and sweatshirts, or hats, or maybe it's shoes, or maybe it's leather goods, belts and purses. All kinds of different classes exist. There's an exhaustive list of them, and they're constantly updated and changed. So you have to make sure that you're filing in the proper classes for where you want to use the marks. Strength of the mark will dictate not only how easy it is to enforce, but also how easy it'll be to register. So made up words and things are typically easier than descriptive marks, which oftentimes are never allowed. So there's also consideration of whether you should register to just use it, and then using searches often saves money. Even though it costs money up front, it can save you money in the long run. Madrid Protocol, very similar to the PCT for patents. It allows you to file multiple trademark registrations in multiple different countries all at the same time versus filing directly in each of those countries. So national filings, you need someone in that country to do the prosecution for you. And then you have 6 months from first filing to claim priority in those national filings. Madrid, it must be based on an existing national application, like one you would file in Canada. And if you have many, many jurisdictions you're filing, it can be cost effective. But if you're only filing in a handful, then it's more cost effective just to enter them directly. So examples of fees, what are you looking at when you're going to prosecution and drafting? So this is a breakdown of some lawyer and legal fees from 21, I believe. So this is all patents. A simple patent application nationwide in Canada should cost you about $7,400. In Ontario, it's a little over 10 grand. Simple trademark registration, similar story, little under 1,500 and a little more than 1,600 in Ontario. For a patent audit, that would be looking at your assets and determining where they stand and how powerful they are. You can see that the costs vary anywhere from 5,600 to 10,000. And then a patentability search nationwide, you're looking at about 1,800, and in Ontario specifically about 2,500. And from my experience, these numbers are fairly accurate based off of all the fees that we get back on our statements of work. And so you can kind of expect those sorts of fees to be what you're going to find when you go to try and file either a patent or a trademark. In addition to those drafting fees, you're also going to have governmental fees and possibly others. So patent office fees can include filing fees, transmittal fees, search fees, request for examination fees, maintenance fees, both under prosecution and once the patent is issued, and then final or issue fees. Those are all common fees that you'll find that patent offices may charge you. Some factors that will impact how much those fees are would be the size of the applicant, your company. The fees can be slashed drastically if you're a micro or small entity versus being a large entity, having 500 employees or more. Whether the patent filing is electronic or paper, almost everything is electronic these days. They charge you more if it's by paper. Number of pages in your application will dictate cost. Number of independent claims and the total number of claims will also dictate cost. Who your ISA is, the International Searching Authority, they charge different amounts. However, if you are filing a PCT application as a Canadian, you would have to do it through the Canadian Patent Office. They're your only option. Translation fees also will add on to the cost of getting your application prosecuted. So you'll need a translator who's specialized with complex IP language. You can't just have a run-of-the-mill translator, or you'll get a very terrible translation of your claims in particular, but also most likely the rest of your application and figures. The costs vary across different industries, and the cost per word also varies by location. And the languages also will dictate costs. So an average patent application is about 9,400 words. Translation fees of anywhere from a quarter to 50 cents per word. You can see that those translation costs can be quite expensive. I recently just reviewed a few statements of work where translation costs were $8,000 and $10,000 and $15,000 for applications. So it's a big contributor to the cost of your patent prosecution. And so make sure that you need to enter a jurisdiction that's utilizing a different language and that you have a market there before you decide to just file, because as you can see, the fees can be quite high. So that is the run through of my presentation. We can now have any questions that you would like to ask. I'm all yours. Sorry, I can't hear you, Nicole. Still very faint. We will wait 1 second. Nicole, can you write in the chat and then I can read it? Yeah, so this question was interesting to me. How do you protect IP with website downloads? So I wasn't quite sure what this question was getting at. So I'm assuming that it has to do with you have a website and you're going to allowing content to be downloaded from the website, and you would want to protect the IP, and I would assume it would be the download would be where your IP is situated. So with software, there's three different avenues really that most commonly are used to protect software. One is copyrights. That typically would only apply to protecting the source code itself in the embodiment of how it's written. It does not prevent anyone from copying the functionality of your software and then building another product that's based just like it. Rather, it just protects the exact formulation and how your source code is written. So copyright doesn't really help in this scenario at all. The other way would be trade secrets. If you're able to maintain your software on your own servers where no one else has access to it, then obviously you can dictate who can see that code, who has access to it. You can have confidentiality agreements with all of your employees, and only those who need to see it and work on it would be able to access it. And none of your clients or users would be able to see the underlying code or what it's doing because it would be on your servers and you control all that. In this situation, if you're actually allowing someone to download your IP, then the best way for you to protect yourself is through a patent. So you would get a patent over the software. You would make sure that if you want to start accessing the market, you can file a provisional application at first. You don't get anything from that other than a priority date. You would still have to file your full application and get it issued before you would get any protection over it. But by filing before you set and allow people to start accessing your software, then you've got the ball rolling on the protection aspect. And you can feel confident in figuring out the market and allowing people to start to play around. You can make improvements and that sort of thing. And you can also tell the people, anyone who's accessing your software, that we have a patent pending on this because we filed, which gives you a little bit of notice to them that they can't just take this and go do what they want to with it. The best way of protecting your software is ensuring that you capture the core innovation that's in your software that no one else is doing, and make sure that you protect it from all different directions. So don't just protect if a competitor were to utilize the same sort of functionality and software and started selling it. Also draft claims from the user's point of view. So if a user is using that software and performing functionality that software allows them to do, make sure you draft claims that protect both that side and what a competitor would be doing from that side. And if you have individual corresponding actors that are exchanging data, try and write claims that capture one side of that exchange separate from claims that capture the other side of the exchange so that you have all different directions covered in your software patent. It looks like the next question is selecting a patent lawyer. What are the most critical questions to ask in order to assess the best fit for your IP? It's a great question. It really does depend on the individual industry that you're operating in and what you want to get out of your patent counsel. And so years of experience and cost are going to be the two biggest aspects that you want to look for. So it's kind of a catch-22. A lawyer or agent who's very experienced in the industry that you work in probably also has other clients that work in that industry. And so they may be conflicted out of being able to represent you because they already represent other companies doing very similar things. However, someone who has lots of room to operate in that particular sector may not have a lot of experience in it. So it is important that at the outset you find someone who's experienced in what you're doing, and then of course doesn't have any conflicts of interest that keep them from representing you. So fees for the entire patent application process, and does that typically include additional costs I should be aware of? Yes. So you can say on average about $10,000 for an agent or lawyer to draft your application, just splitting the difference between very simple mechanical applications and much more complex pharma and therapy applications. Looking at about $10,000. After that, you have the governmental filing fees. Assuming you're filing in a single jurisdiction, say Canada or the US, you're looking at another $2,500, $3,000, depending on the size of your entity. Maintenance fees that are ongoing are about $1,000 per year that you're pending in Canada. They don't charge that in the US, but that starts after the patent is issued. And then you'll probably have on average 2.5 to 3 rounds of office actions with the patent office before you get an allowance. Each round of office actions, you're going to be charged from your lawyer or agent probably around $3,000 to $5,000 to respond to them. So if you go the top end, 3 times 5, another 3 for the filing, and then 10 at front, you're looking at $25,000 to $28,000. And that's just to get your patent issued. If your patent doesn't issue, it still costs you the same amount of money. And that's the problem, right? You really need to make sure that you've done the research up front to know that it's not something anyone else has done, that you're doing it in a unique and innovative way, and that what you're doing can be patented. And those questions can all be answered by a good patent counsel or agent. What are the common reasons for rejections? You're looking at obviousness, non-uniqueness, non-inventiveness, and then subject matter rejections. Subject matter would be it's a mental process, or it's a financial transaction, or it's something humans do typically that you're just utilizing a computer to do. Those are all very typical subject matter rejections. Obviousness would be that one or more other references are teaching the same thing that you're saying you're doing. Anticipation is very similar, but it's one single reference. Inventiveness just means that you're not taking an inventive step over what the prior art is teaching. So all of those different aspects come into patent prosecution and what kind of rejections you're going to see. How do you address them? 2 different ways. You either argue around them, or you amend your claims to get around whatever the art or the examiner is saying. Those are the 2 ways that you respond. Yep. And Nicole put something in the chat there. So if you guys want to read that, you have any more questions, just go ahead and write it into the chat. Should you always apply for a provisional patent first? And does it ensure the invention is protected during the application process? In my experience, yes, there's really no reason not to file a provisional patent application in the US first. Again, it puts a priority date down for you. You can test the markets. You can do some other things. You can figure out any innovations or tweaks you need to do to your product before you file your full application, and you still get the earlier priority date. Of course, any improvements you made or anything you didn't describe in that application will get later filing date, but the core innovation should not have changed from when you filed your provisional to when you file your full application. It does not protect your innovation in any way. It actually is not even looked at by the office. Rather, they receive this PDF file typically, and it's got a cover sheet, and they just make sure that the cover sheet says all the things it's supposed to say, and there's actually something there, and then they just store it. The only reason it ever gets looked at is if someone down the road litigates and says that they have an earlier priority date than you, and then you have to go and see if what's in your provisional is what's actually in your non-provisional, and that they match up. And then they'd look at the provisional filing to see what's in it. What aspects of software are eligible and patentable and what aspects are not. So again, the functioning of the software is what you're really protecting against. You can't patent things like data exchange or data storage, or just simply, receiving data, analyzing data, sending data back out. Typically, there's different tests in different offices, but you're looking for a transformation of that data or doing something that can't be done short of your innovation, right? Whatever your invention is, it needs to be novel and new and can't be taught by the prior art. So you need to make sure that you have something there in your software and it isn't just a rearrangement of other things that are in the art, or, something that can be easily seen through combinations of other people's software. We have a question came in here from Gail. Case involving infringement of an artistic IP copyright. Infringing products produced in the UK but distributed around the world. Outside of an attorney and IPON, are there any other IP resources that can help me understand enforcement rights in Canada? Yes, so you can go to the CIPO website, the Canadian Intellectual Patent Office, and there are resources available there to determine what your Canadian copyright does for you and what it does not do for you. And then you can kind of see if, right, what the scenario that you are facing, whether your Canadian copyright will protect you in that particular situation, and whether it's of interest to you to take that next step and consult with a lawyer, so that you would then go about the business of enforcing your copyright. I would never counsel anyone to send out any sort of messaging to a potential infringer on their own. It's always best to talk to a lawyer before doing anything like that, because initiation of those sorts of communications can often start a clock ticking, can have other ramifications, and can lead you down a path that you may not want to pursue. So it's important that you talk to someone who is versed in those sorts of things before reaching out and saying, hey, it looks like you're doing something. Can you stop doing it? Because it may have backfire on your way you weren't anticipating. Next question here. How do government programs support creation of IP? IPON just went through the discussion of how we support the creation of IP. It's through funding of the protection, right? So filing both the creation of the IP strategy, any documents, contracts, agreements, IP policies, things that your company can utilize. We also support the drafting of all of that, so that you can get on the right path and you know that you're doing things in the right direction for the right reasons. We also have other programs in the government that help with research and development spend, others with prototyping, some with proof of concept generation. So there's many different players that work in the ecosystem to try and help companies get moving. It just depends on what sort of support you're trying to access as to which program you would best make use of. And again, you can use them in parallel. You can use them in series, right? If you're working with IP Assist, you're also working with Elevate IP and IPON. It's all fine as long as you're not stacking your dollars. Another question here, how do your clients that leverage IPON evolve with your program offerings as they mature? That's a great question. At the outset, if you're relatively unsophisticated in your IP knowledge, right, the education and the benchmarking is really going to give you a lot of information to absorb. And then when you first start talking to a lawyer or an agent, an IP service provider, that's going to open your eyes up even more, right? You're going to see, oh, there's some things I never thought about, or reasons why I should do this or not do that. And so it can really be a lot of information to absorb. So IPON, my team in particular, the IP team, but also our client management team, work hand in hand with our clients to walk them through the entire process and answer any questions along the way. As they start getting work performed, they're obviously going to be moving into different stages of what they're going to be doing. If they don't have a brand, they're going to develop a brand. They're going to file trademarks to protect that brand, and then they're going to start utilizing that brand as they go to market. If they have an innovation, but they don't have any patent protection, then they're going to file a patent. And then that patent's going to get prosecuted over about 4 years, right? 3 to 4 years before you actually get that thing issued. And so as they're a client during all that time, they still have access to our resources and our team so that they can be helped along that journey. So the more IP they get filed, the more protections they have over their IP, and the more they evolve and mature from an IP standpoint, the better they are positioned to access the market. The more investment dollars they'll be able to acquire, because they'll be a more attractive investment because they have IP awareness, they have an IP portfolio, and then they have IPON backing them up along with any of the other ecosystem partners that they're working with. So as the companies come in and access our services, they mature along their journey, and then hopefully they become successful and don't need to rely on our support any longer, or they get so big that they can't access us for eligibility reasons. Either way is great. Next question here, how does cost vary for patent applications? Again, it depends on the jurisdiction that you're entering, which country you're filing in. Each office has different costs. If you're going foreign, you also need to have foreign agents doing the prosecution in those jurisdictions, and so they charge you money. And then they have different kind of maintenance and ongoing annuity fees and those sorts of things once your patent actually issues. Question about, will the slides be available? Yes. Yes. You'll be able to access the slides. Nicole will be able to take care of that for you. Let's see. What inventions are not subject to patenting under Canadian law? Again, that's kind of anything that's abstract, right? Ideas are not patentable. So if it's an abstract thought of the human mind or a mathematical algorithm or something like that, you cannot patent it. The only thing that is patentable is going to be something that's tangible, usable, right? That's innovative and novel against other things that are out there. And so, again, there's carve-outs that kind of capture the functional aspects of software, but you also then need to ensure that it's either captured as a method of doing something or as a computer-readable medium. In other words, the memory in your computer or a disk or something, a non-transitory communication between different processors in your computers. How can IP help to grow our economy and create local jobs? It's a great question. That's why IPON exists. The idea is for each of these companies we're working with, we have over 350 clients now, and we're intending to support 1,000 to 2,000 clients at a time through IPON. As these companies acquire IP, grow their businesses, get investment dollars, enter markets, start selling their products, start hiring more people to support the development of new products and the product lines that they already have. That's how we're going to help our economy and create local jobs, is by supporting these small companies that exist within Ontario and not letting them move to the US or get sold to a foreign investor, but rather stay in Ontario and continue their journeys here. So that's a whole idea of our program. Next question, understanding copyright regarding using various fonts. Fine print online is vague or general. Yeah. Is there a way to know for sure which fonts can be used commercially, and how do IP laws work with original art pieces? So original art pieces, IP, you're looking at a copyright, right? Any artistic expression, you're going to be turning towards copyright because it isn't a new or novel, useful invention. So it's not a patent. And it's not a word, logo, brand, scent, smell, color, anything like that would be trademarked. So is there a way to know for sure which fonts can be used commercially? So that's a great question. I believe that this is focused on, if I want to put print out there, can I just use the Microsoft Sans Serif, or can I use Arial? What kind of font can I use in my commercial publications and things like that? If you are looking at doing specific font for your own company and you're trying to develop that, then you can work with someone and you can get your own font created. And that, of course, as long as your contract with that company is specific to who owns the IP and the font after it's made, then you'd be able to continue utilizing it commercially however you wanted. As far as other sorts of fonts, when you go to the terms and conditions on your particular computer interface that you're using, whether it's Microsoft or Apple or whatever, there is a T's and C's section as to the font downloads that you're able to access, and that should dictate how you can utilize those fonts. And typically, the majority of them can be utilized commercially without any restrictions. How do I protect my writing projects? Again, that would be through copyright. You do not have to register a copyright, but it does afford you some additional advantages if you ever need to rely on it. But rather, every time you write something, you just put a copyright notice on it, and that has now been copyrighted. And so just if you do that as you continue doing writing projects, then you can trust that you have a copyright over it. However, enforcing that copyright and keeping someone from copying it are two different beasts. In order to enforce a copyright, you most likely would have to turn to a lawyer in order to do that. Discussion of current and future copyright and patent rights and liabilities as related to usage of AI in creative endeavors. So we're looking at the difference between Canadian, US, and European law. Yes. So AI is a hot topic, particularly generative AI, which is different than just other AIs in typical. Each of those different jurisdictions, Canada, the US, and the European Union, all have different laws as they relate to AI. The EP and the US are typically leaders in these areas, and they have both issued directives or guidelines as to how they're going to treat AI in the patenting concept. So if you're looking to patent an AI innovation, then I would turn to those resources, those guidelines that the US and the EP has put out, and try to adhere to all the steps that they dictate within those publications in order to properly protect yourself and give yourself the best chance of getting a patent issued on your AI innovation. I know the US has indicated that AI can't be an inventor, but rather be the human that set out the instructions for what the generative AI was supposed to produce, and they would be the inventor of whatever the generative AI then produced. However, knowing that if the generative AI was not owned by them, but rather they were utilizing it under a license, then necessarily they would not be able to go to market even if they got a patent over whatever innovation the generative AI created, because it was created through something that was owned by someone else. And so if you don't own, it would in fact be a innovation patent. So you would have a patent over the innovation that generative AI created, but you would not have a patent on the generative AI itself. And so you would not necessarily be able to go to market and utilize that innovation without getting the rights signed over from whoever owned the generative AI. So, but again, it's constantly changing. It's very complicated, and it's an area where very intelligent minds are disagreeing on what is and is not patentable in our different jurisdictions. So, how do you determine when the new product is unique? The best way to figure that out is to run a search. So you can start as simple as a Google search to figure out if there's anything else out there, and then you can pay search firms or lawyers or agents to run more advanced IP and patent searches to determine if something else is already described in the prior art or whether it is new and novel and would be able to get a patent issued on it. And how do you become an IPON partner and access all of our fun things? Just go to the apply button on our homepage, and that'll get you right to the application. Adam?
Yeah, no, thank you so much. Adam Keller with the County of Simcoe. I understand there's some technical difficulties on Nicole's end, so just happy to jump on. And are you seeing any more questions on your end, Jarrod?
I have not seen anything else come through. So if anyone has some questions, submit them in the chat, or I don't know if you can unmute them, but if they can just put them in the chat, we can read them.
Okay, perfect. And certainly, we can certainly follow up after as well if there's additional questions, kind of as you're thinking about today's session. And so with that, we'd just like to thank everyone for attending today's session. Again, sorry for the technical difficulties. And we just wanted to note a few things. So a survey will be sent by email, along with a recording of the session just after the event today. And so please watch for that and let us know what you think. And if you're interested in hearing from more experts, information from the series can be found on our website as well, with a lot of other great topics. And so thank you again to Jarrod and the team at Intellectual Property Ontario for your time and insights today. Thank you to all the partners involved in making these sessions a success. Thank you for everyone for attending. And, we certainly wish everyone a fantastic rest of the day and rest of the week.
Right.
So with that.
Thank you. Yep. Thank you again, Adam. And Mike, I'm going to answer your question in the chat here before I log off. So you should have the answer to that here in a little bit.
Great. Thank you so much, everyone. Have a great day.